New York University School of Law. I direct a program for foreign lawyers on basic American law skills. My views do not necessarily represent those of the university. I've clerked in the federal court, I've worked for an international human rights organization, I practice international transactional law. In the past several years, I've written several law review articles and co-edited and co-authored a book on vaccines. And I respect deeply your interest in protecting the public health, and I recognize that 5 of you are on record supporting SB 277. I'd like to give you just a few basic facts about vaccines before I tell you what I consider to be the 4 serious flaws with the bill. The basic facts about vaccines are that as a legal matter, they are considered, like all prescription drugs, unavoidably unsafe. Because of that, in 1986, Congress passed the National Vaccine Injury Act, which created a federal compensation program. And that program has paid out $3 billion and has compensated over 3,000 victims, including approximately 150 who have died from vaccines. In that 1986 law, Congress gave virtually blanket liability protection to vaccine manufacturers and to healthcare practitioners who administer vaccines. And in 2012, the U.S. Supreme Court, in interpreting that law, held that no court in the country may hear a claim for vaccine design defect. So this is a product, these are commercial products, some of them have but one manufacturer, and they are extraordinarily insulated from any kind of legal liability. So with that, let me turn to the 4 problems I see with SB 277. First, there's the problem with informed consent. Medical informed consent. Second, there is the problem that this is a California fundamental right to a public education. This is not federal law, it's state law. Third is the problem with equal protection and discrimination. And fourth is the requirement of legislative authority for vaccination mandates. By contrast with the current bill, AB 2109, which is now law, works and strikes the appropriate balance on all 4 factors. If it's not broken, don't fix it. I don't believe SB 277 should pass out of committee, and I do believe that 2109 strikes the right balance. So on the 4 points, 1, informed consent. The global standard for ethical modern medicine is prior, free, and informed consent for all medical interventions, including preventive ones. The United States endorsed this UNESCO declaration in 2005. It's called the Universal Declaration on Human Rights and Bioethics. What you currently have in place, AB 2109, ensures a measure of choice. To be sure, it's a burden choice. Parents have to fill out a form, they have to get counseling from a doctor, but a parent with a strong religious or other conviction may opt out. And it is a very, very small percentage of parents that do so. It's under 3%. Without some measure of realistic choice, and I do not believe that medical exemptions or homeschooling present viable options for the majority of those who have resolute convictions against vaccination. This bill will be coercive, and parents will be vaccinating their children under duress, invalidating any notion of informed consent. In employment, lack of consent is forced labor. In military service, it's conscription. In contracts, it leads to invalid contracts. In intimate relations, it's called rape. And in medical treatment, it's battery.
Wait. Rape's a loaded word, and as the chair of the Legislative Women's Caucus, I don't take these that lightly. So,
I don't either.
So, well, to analogize this to rape, I think is a little bit off the rails. So let me ask you a question, if I may. I'll bring it back. Are there any cases that you can cite that on informed consent that refer to vaccinations of children before going to school?
I'm not sure I understand the question, I'm sorry.
The question is, you talk about informed consent. I'm asking you if you know of any Supreme Court or court cases that call for the vaccination of children before they're going to school as an issue of informed consent.
There are Supreme Court cases on informed consent. I'm not aware of any that specifically at the moment refer to vaccination.
Okay.
Yes, yes, understood. Okay. And my point is not that this is forced vaccination, but my point is that it is coercive, and that parents are now, if you pass SB 277, they will be deciding to vaccinate under duress if homeschooling and medical exemptions are unavailable to them.
I understand. I'm trying to get the direct connection. Okay. Are there any cases that refer to this, make that analogy?
Not on a federal level that I'm aware of.
Any in the California that you're
I will get back to you on that. I'm not aware of any. I will get back to you on that point.
Thank you.
Thank you. Okay, the second point is about California's fundamental right to an education. So unlike many states, California guarantees its children the right to a public school education. This is in the Constitution, and it's also been interpreted in Serrano v. Priest. Serrano, which would be the controlling law and a challenge to SB 277, states, "We indulge in no hyperbole to assert that society has a compelling interest in affording children an opportunity to attend school." So it's not merely an education, but it's the right to attend school. And given this compelling interest, course must apply strict scrutiny in assessing any restrictions on this fundamental right. So as the ACLU letter of concern notes, the current bill provides no explanation why barring unvaccinated or partially vaccinated children reflects a compelling state interest. Currently, the AB 2109 law allows children who are not fully vaccinated to be kept home from school during any disease outbreak. This is the system, the state police power clearly permits that, and this has worked in 48 states for more than 50 years. Well, in all 50 states, in fact. And to date, SB 277 has made no showing that throwing children who are partially vaccinated out of school is the least restrictive means possible to attain its legitimate public health goals. By contrast, existing law strikes the right balance. Students are identified who are partially vaccinated to the school district. They attend school like any other healthy child, and in the event of a vaccine-targeted illnesses, they must self-quarantine or they will be restricted from attending school. There can be little doubt that if SB 277 goes forward and becomes law, it will be challenged in state and federal courts. This bill does not meet California's high bar. Professor Rice talked about the federal standards. It doesn't meet California's bar. And it seems to me that it's important that this committee...
If it doesn't, I'm sorry.
No, please.
If it doesn't meet California's bar, what is the bar that California has? Sorry, let me try to finish.
Sorry.
Pretend I'm the judge here, and you're the attorney. So I get to ask my question without being interrupted. Assuming you say it doesn't meet California's high standard, what case sets California's standard that you're referring to as far as an education? Because there was some reference to Serrano versus Priest and had to deal with access based upon class or race or other things other than vaccinated children.
Serrano v. Priest does not deal explicitly with vaccination, but it does deal with the right to education. And you're right that that was about financing, and that was about trying to equalize financing across different school districts, particularly those that were poorer than others. So it doesn't specifically deal with vaccination, but it does deal with the fundamental right to education. If we are depriving, as SB 277 would, a class of students from access to a public education based on vaccination status, I believe that the compelling interest must be shown, that is the ACLU's view, and that then the state must show that its method to address this compelling interest is the least restrictive possible. That has not yet been done, and it hasn't been shown why AB 2109 is not satisfying the state's compelling interest. And indeed, that is the standard that is being used in 47 other states productively. And there's no question that the state has the right to quarantine students in the event of outbreaks. And to the best of my knowledge, despite the outbreak in Disneyland, there were no schools in California that were closed down because the outbreak spread to those schools. So the connection there is not obvious, at least to me. I also want to touch briefly on the legal problems that would arise in taking away education from special needs children under the Individuals with Disability Education Act. Under federal law, special needs children are entitled to a free and public education that includes annual individualized educational plan reviews and a host of special services, including occupational therapy, physical therapy, and speech therapy. Many of the children whose parents are currently enjoy exemptions are special needs children. It seems almost impossible to imagine that homeschooling would be able to satisfy all these requirements. Furthermore, a problem with SB 277 will be in its enforcement. The parents here today are unlikely to comply with the vaccine schedule. They will either be forced, it would violate their covenant with their God or their conscience because rightly or wrongly, they believe that they would be putting their children at risk of severe injury or death by vaccinating them. How will you possibly enforce this with parents who won't vaccinate and cannot, for economic or other reasons, homeschool? Will you be willing to remove the children and force vaccinate them as wards of the state? Will you be willing to throw non-vaccinating parents in prison? And what happens if the state does vaccinate a child whom it has removed and that child is severely or injured or dies? What will the state do?
Where in this bill does it talk about throwing parents in prison?
No, but what will you do with the parents, many of the parents who are...
Now, this is, I'm sorry, but
No, I'm saying that
there's nothing in this, I mean, there are enough concerns raised to kind of push it to a level. Now we're talking about putting parents in prison. I think does a disservice to those who oppose this bill. Let's talk about what's in the bill and what isn't, but I don't see any connection. There's no allegation that people are going to get put in prison. So I think you don't do yourself a service by talking about things that are not even within the contemplation of this bill.
I ask rhetorical questions. My question is, what will you do with non-compliance? I think that's a reasonable
That's
question.
a reasonable
And that
question,
was my
but to
question.
suggest that we're going to put people
Well,
in
I don't
prison
know what you will
is
do.
not, well, that's, this is an appreciative audience, not a vocal audience, or we won't have an audience. So let me just ask the witness who's representing the opposition. It's a rhetorical question, what are you going to do? But to suggest that people are going to be put in prison, I think does a disservice to your cause. So please try to stay within the framework. You can ask rhetorical questions, but not to suggest things that are nowhere contemplated by anybody, in which all they do is inflame this discussion, which doesn't need to be inflamed. So please.
Thank you. The third point is discrimination and equal protection of the laws. SB 277 stigmatizes and discriminates against a small minority of parents and children who choose to selectively vaccinate or not vaccinate. I do believe that SB 277 would create a kind of segregation in its current form. It would discriminate against children on the basis of their biological vaccination status and not on the basis of any actions or any immediate threat to the public health. It's hard to see how this is distinguishable from other biological characteristics, such as skin color, ethnicity, gender, or sexual orientation. People who are unvaccinated are not walking time bombs of disease. If they're healthy, they're healthy. If they're sick, they must stay home. It's simple, and it's worked for over 50 years. I commend to you immunologist Dr. Tatiana Abukhanich's clear letter reviewing to you, vaccine by vaccine, why healthy unvaccinated children pose no greater risk to the public than any other children. SB 277 also suggests a slippery slope. If you will deprive these children of a public education, what other steps towards segregation might there be? What other steps towards creating herd immunity? We know that separate but equal hasn't worked. Separate but equal, I do think, is what 277 proposes by excluding children who are partially or unvaccinated from school.
Thank you very much. Next witness, you have